So the topic for today is going to be on youth justice, or also known as the Young Offenders Act of Canada, a subsection but a very important portion of the Canadian Criminal Code, especially for those who are under the age of the youth. So let's get started. Now, the principles of youth justice are threefold. First is the protection of society is the most important objective, which means achieving through the prevention and meaningful consequences for the actions that have been committed. But chances of rehabilitation are also possible. While young people should be held responsible, but should still be held separately and treated separately from adults under the Canadian Criminal Code. And because of that, parents and victims must have a role in the youth justice system, as they are treated differently compared to the adults. Now, the Young Offenders Act became it in 1984, and it will include ages of 12 through to 17 in a rather inclusive, holistic criminal approach. The Young Offenders Act replaced the original Juvenile Delinquents Act of 1908 where it would also use the ages of 17 through to 16, or possibly add the age of 18 with the welfare approach. But because of various social changes that have occurred in Canadian society, such as the Charter of Rights and Freedoms and the repatriation of the Canadian Constitution, the Canada Act of 1982, this was also another substantial change. Now, the Youth Criminal Justice Act was passed in February 2002, but it did not come into effect until April the following year. It is criminal law, which means offenses under the criminal code and federal laws are applicable, even though there are a separate set of guidelines and rules governing the youth. It is the ages of 12 through to 17, but the reason why it is at these ages is because too young, under the age of 12, was thought to be too young to have any sort of a criminal intent. Whereas if you reach the age of 18, it keeps the criminal and civil code in line and keeps the age uniform across the entire country, with the greater chances of possible rehabilitation and also reintegration back into main Canadian society there. Now, with the trial procedures, all trials should be conducted in either the family court or the youth court. There are actual separate different courts for these cases, but all trials are conducted by a judge. And because of that, there is no preliminary hearings, unless the Crown is seeking to have an adult sentence against the youth that has been charged. Now, public and the press may attend the hearings. Media can also report on it, but no one can actually identify the youth. They cannot show their face, their name, for it is kind of like a protective umbrella, a bracket around the youth because of the rehabilitation. While adult sentences are possible for youth who are 14 at the time of the offense and commit a violent crime, it is no longer automatic for the 14-year-olds to be accused of presumptive kind of offenses there, because age is a reduction from the Young Offenders Act, but various provinces can opt out of this. This idea of the young offenders is that there is like this protective bubble for those who are in question, so they can be rehabilitated and be reintroduced back into society. Now, the rights of the offender, there are a few. First, that police have alternatives other than arresting the suspect who is youth. Recall, there actually are several stages that need to be done for someone to be arrested. There is also extrajudicial sanctions, apologies, compensation, or community services which can be offered to the youth, and these are not always options for the adult if it's charged as an adult. There are also legal rights under the Canadian Charter of Rights and Freedoms that apply to youth, and they have a right to a lawyer and an adult present while being questioned. The fact that an adult is required during questioning is a very, very important very, very important point there because of intimidation as one of the many sort of reasons for it. And also, there are voluntary statements that protects youth from being questioned improperly. They have a right to appeal their sentence once it's been handed down after the sentencing hearing. But first and foremost, as always, their identity must be protected from the general public if they are going to be tried as a young offender. But the Crown can always uh, ask a judge to have the youth charged as an adult, which means all these protective umbrellas, these protective brackets will no longer be applicable, which means their identity, name, and such would be made public. Now, for sentencing options, Section 38 of the Youth Criminal Justice Act is the important part you want to remember. That's because the main principle, holding youth accountable with a sentence that is fair, meaningful, helpful in the process of rehabilitation. A judge will examine a pre-sentence report, a report that contains everything, all the background about the youth during the sentencing. It's everything from your swimming records, school records, community groups. It's everything and anything about youth is known, is presented in the pre-sentence report. The judge wants to see and know everything that is there, along with any sort of psychological or medical assessment that may be required for the youth, because they are young. They still have a tremendous amount of time left in their lives to still be a law-abiding, productive citizen in society. Now, factors to be considered before sentencing are, first, the extent to which the youth have participated in the act of the offense, what harm to the victim and the community, what kind of reparation has the youth made to the victim, has the youth spent any time in detention, does the youth have a previous criminal record, and the content of the victim impact statement during the trial. These are the factors that are applicable. While sentencing is being handed out, it is a very fine balance between the youth, the juvenile, and the overall Canadian justice system. This is for the criminal code, not the civil matters. That's something different. But for sentencing, all community-based sentencing options must be considered other than custody. All other options could be an absolute or conditional discharge, probation, fines, compensation, personal or community service, or an open or closed custody arrangement for the youth. For this, when you're dealing with the youth, there is a tremendous amount of people that will now be involved in the overall plan for the youth. During the sentencing, custody and supervision order, like a court order that specifies conditions of custody, such as 2/3 of the sentence spent in custody, 1/3 under community service with supervision can be done. For sentencing, there might be a youth worker who is a person appointed by the government to monitor the youth's progress. There might be a post-custody supervision that's aimed at helping you to reintegrate into society as well. With the sentencing, though, in most cases for probation or custody or supervision, it will not exceed 2 years. But sometimes, in a real serious offense, it can be as high as 3 years. Whereas a regular court or other ones, it could be, if the youth was convicted of first-degree murder, they might be in jail for 10 years. Second degree could be a maximum of 7 years, which, as you know, is different from what an actual lifetime sentence would be under the regular Canadian Criminal Code, that being 25 years rather than the 7 or 10. With the sentencing too, the Crown may seek an adult sentence if the sentences are not adequate, and if the Crown felt this is not holding the youth accountable enough for their actions. And the youth must be at the age of 14 at the time of the offense to be part of the young offenders. Factors to be considered is the youth's background, the offense, the age, maturity, and the character that was of the youth who was accused. And the youth must be notified before trial of what they are going to be facing. The youth also has a right to a preliminary hearing and a trial by a jury. But a lot of times it tends to be by a judge, but they do have a right for a jury. If under age 18, they will serve time in a youth penitentiary center, not a regular system. Youth are given adult sentences for murder are eligible for parole earlier than adult. At any stage in sentencing, court may refer the case to a conference to determine the most appropriate sentence. And a conference can include meeting with the youth, parents, meeting with the victims, professionals, other members of society. It's everyone is on board when dealing with the sentencing part. But one thing too is the records. Criminal record or criminal offenses have a criminal record, which is quite severe for an adult. For our youth, records involving extrajudicial measures are destroyed after 2 years if there has been no further offenses. Additionally, records and the access to records for the youth, parents, police, or those who are involved are allowed there. Victims and schools may have limited access to this record, but the record can also be expunged after a certain time period and if all the conditions have been met, because as we wrap this up, one of the main points for the Youth Criminal Justice Act is to rehabilitate the youth, to give them that second chance to be a productive, law-abiding citizen in society.